giving my client, the father, primary legal custody. You ordered that he was allowed to give the mother visitation at his discretion and ordered that the mother pay child support.
I'm sorry, and this case started with me? Was it ever before another judge?
Not to my knowledge.
It just feels like he's been manipulated and manipulative.
We're here today on our motion to dismiss plaintiff's motion for, I believe it's now a petition for modification of parenting time. It's also a citation for contempt, motion for attorney's fees, and also I believe there was a amended petition filed requesting a modification of child support. Just briefly, I think you said you just looked over your notes. You've, I believe, been on this case since the initial divorce took place back in 2010 between the parties. Subsequently, in 2019, my client, Mr. Barnes, filed a petition to modify custody, and the parties reached an agreement. They executed a modified parenting plan in December of 2020. And then following that, Mr. Barnes filed another petition in 2022 requesting to modify custody in the Superior Court of DeKalb County. At that time, he attempted to have Miss Eldridge served by special process server. He attempted service by publication. At the final hearing, Miss Eldridge did not appear. And the minor child who is subject to this action presented the court with an affidavit of election stating that he wished to be placed with his father as the primary custodian. Your final order you entered in this matter noted that the mother did not appear for the hearing. You also took notice that the minor child had suffered mental abuse at the hands of the mother and her spouse.
I'm sorry, when was that order? What case number?
That was April 17th of 2023. That's
2023. Okay, hold on. I'm looking. I just pulled up the
I have the case number if you'd like it.
no, I see them all. So I pulled up the first final order in the 19 FM case. It's not too old, so I should have some memory, but right now it's just not pulling up. But usually as you talk, maybe it'll come up. Usually I put my little notes in here so I can have some recall. And it normally works, but for some reason I'm putting up blanks right now. And this case started with me. Was it ever before another judge?
Not to my knowledge.
So another judge didn't handle it and send it to me that you're aware of?
Not from all of the paperwork I've been able to pull. Your signature has been on everything.
Okay. All right then. So all right. I don't have actual recall, but probably as we go along, I will. All right. So your position is go ahead and tell me what your position is again.
Yes, Your Honor. So you entered an order on the 17th, April 17th of 2023, giving my client, the father, primary legal custody. You ordered that he was allowed to give the mother visitation at his discretion and ordered that the mother pay child support in the amount of $519 per month. Following that hearing, just barely, I think it was 2 months later, Ms. Eldridge filed her petition for modification of parenting time against my client, which is what we are here asking to be dismissed at this time. According to the statute 1993B, the modification of an entry of visitation rights is subject to review and modification every 2 years, unless there is some showing that there has been some change in any material condition or circumstances of either party or the child. We do not believe that that showing has been made. Even today, we are still, I believe, just past 1 year since the order was entered. And so it is still, we still do not believe that the plaintiff has made any showing that there has been any material change in the conditions or circumstances that make modification of your order from April 17th of 2023 necessary at this point. We also request that plaintiff's request to hold defendant in contempt be dismissed. The amounts that are pled in plaintiff's petitions are varying and unclear. At one point, they are in separate amounts based on what the contempt action is for. Then in another petition, it claims to be well over $12,000 plus interest, which is a number I do not know how that amount came up from any of the numbers that I have received so far. And then finally, plaintiff requests to modify child support. We request that that be dismissed as well. Just prior to a brief hearing we had on this issue in Gwinnett County before the case was transferred to DeKalb, I was presented with a letter saying that plaintiff had been released from her job at the time, the Friday before the hearing that we had. Since that time, I have been unable to verify that plaintiff is no longer working. I have also been unable to verify the amount of income or the finances of the plaintiff since that hearing. So I cannot consent and believe that any request to have her child support modified should be dismissed until I can verify that information.
Good morning, Your Honor.
Good morning.
I represent Ms. Jasmine Eldridge, and I think the court probably was referring to another judge having dealt with the case because it was transferred to DeKalb County from Gwinnett.
Okay.
Client, when she initially filed her modification, she had to file it where the defendant lives, and he lives in Gwinnett. He does not live in DeKalb. The prior actions is where he had always filed against her, and she is a resident of DeKalb County. When we had a hearing on this matter in November of 2023, the judge in Gwinnett indicated because this court had did the initial divorce and the court had signed the order on the first modification that Mr. Barnes filed, as well as signed the second order that was actually filed, that it would be better for this court to hear these issues as opposed to Gwinnett. The parties then consented to change venue from Gwinnett County back to DeKalb County. So that order was transferred, I believe, in December, and then we got a case number towards either the end of December or early January. I then immediately filed for a motion to have the court to hear all of the matters that were pending before the court in Gwinnett County, which was the petition to modify visitation and parenting time, which, by the way, my client has none because the defendant in this case has chosen not to allow her any access to the child. Very limited phone contact, if any, and no visitation at all. In fact, I don't believe she's seen this child since early 2023. But anyway, so she's had no access because it appears that his position is, I can decide whether or not you see the child, so you don't get to see the child. He did bring the child to court last time in Gwinnett County. I'm not sure if he's there with them today, but he took him out of school when we were in Gwinnett in November for him to come to court to say that I don't know what he wanted to say, but he was there. So she is not arguing this issue about whether or not his election was his election. If he wanted to live with dad, that's fine. She does disagree with this allegation that she and her husband mentally abused this child. As Ms. Verheyen has indicated, When this case was actually filed in DeKalb County, I don't think she was properly served, but even if she was, she did not appear at the final hearing. She had complications from a pregnancy that caused her not to be able to appear in court. So she provided no defense to the allegations that were made in the original petition to modify that was filed by Mr. Barnes in 2022. And then the final hearing was held, I believe, in March or either April of 23. And a final order was entered April
I
17th.
think the hearing is in March, and I kind of feel like now that things are coming back to me, I think I interviewed him.
I think you did.
I think I interviewed the child because of the allegations, and I think of his age.
Right.
I kind of want to think he may have indicated he was at Lithonia High School or going to Lithonia High School. So now I do have recall. I actually interviewed him, and the reason I think it has mental abuse on there, was that was the court's finding at the time based upon the statements, that he made,
Right.
And how he felt about his circumstances at the time. So I don't think, I think the court was very mindful, even though she wasn't present. I didn't make the decision, just kind of like what he said. I actually did interview the child.
And I believe that's in the order. It states that the court interviewed the child.
Okay, it does say that. Okay, good. All
The
right.
court made a determination that dad would have, it
So I-
says joint legal, but
I
dad
think-
has to
Yeah,
file.
I think the thing is that dad would exercise discretion in how he would allow visitation. So he was supposed to, it wasn't that she doesn't have visitation. It's just that the court, well, because the child was 14 and he could tell, kind of dad what's going on. Dad would then be able to use that in his discretion of how the mother would visit. That's how it's set up. Because of his age, and because if anybody is emotionally abusing him, you can come home and tell dad, and then dad can change the parameters. But I don't think I indicated that mom is not to have any visitation.
Well, the language doesn't say that. The language specifically says that the dad will determine
Yeah.
what the visitation would be.
Yeah,
And
go ahead, exercise primary
so far, it'd be none.
No,
And
I didn't say it would not. Where are you reading none?
let me go back to the language. Because there was a schedule. There was actually an order that had a schedule attached.
All visitation terms.
If I can find the actual language. Because there was a parenting plan, but in the parenting plan, it gave dad discretion. It just says, as dad agrees that the child will have visitation with mom.
Mother shall have parenting time with the child as agreed by father.
Right. Which means he has to decide that it's okay for her to visit, the way I interpret that. And I'm presuming that's how he interpreted it too, because he has decided that she has none. She's had no visit.
Well, I don't think how do you have parenting time if you have none? I think it's supposed to be in his, it is supposed to be in his discretion, but it wasn't supposed to be none.
The effect of the order, Your Honor, I guess is what I'm saying, is that he has not allowed any visitation at all.
Okay, your position isn't that I said she's not to have visitation.
No.
Okay,
But
your position is that he interprets that, your argument is he interprets that to say no visitation.
I obviously I can't speak for him, but the net effect of the order is that no visitation has been allowed, even with my client reaching out asking for parenting time, even
Okay.
for
I
phone.
should say, and your position is that it shapes the modification, that is the material change, is that mother has not seen the child since the order.
Well, at this point, that's what it is. When we filed initially,
what were you initially indicating? Because the way I read it looked like you were saying she had not seen him, and that was only 2 months later.
Right. Because let me back up. Before he even filed the petition, he just kept the child in his care after one visit. This is on the prior order. And the child never came back to mom's house.
Okay.
And he subsequently then filed a petition to modify while still having the child in his care. We know under the statute, you're not supposed to be able to ask for custody while you are withholding custody. But because my client did not present any defense to move to dismiss his petition because he was withholding custody, that wasn't brought up, that wasn't even looked at in this case because she wasn't there and it wasn't presented. But the reality of it was that when he went to visit, and I believe this would have been in sometime in December of, the latter part of 2022, child went to visit with dad and never came back to mom. He then subsequently filed a petition to modify in early 2023. And then a final order was entered in this case that gives him custody and the right to have his discretion on when the child can see mom. That's what the order basically says as far as my client is interpreting it, because there's no schedule that says she gets first and third or any of that.
Right.
It's based upon when dad decides. And every time she's asked, it's been denied. She has not had any access to this child. So at this point, there is material change because he has not allowed her any access. We asked that we at least have phone calls. And so my client was attempting to do phone calls after we left court in November. Then the number was changed. I did contact counsel and let her know, hey, she can't even get in touch with the child now because the number has changed. Dad's
Has mom and dad have discussions, like is dad putting parameters that mom can't meet?
no, none of that has occurred. They don't talk. And his
Okay, so Ms. Breen, tell me where we are with that concept, because what Ms. Banks Ware has presented to the court is that father is rejecting all communications, and that could be a material change in circumstances, even though I believe at the time it was filed, those things may not have been as egregious as she's claiming them now. But particularly at this point, if in fact it's been a year and he has found no space for a visitation, that is alarming to the court.
That's just not true.
Okay. All right. Let me hear what you got to say.
okay.
My client has, and their son has had contact with his mother, and she does have a way to reach him. So I just I don't really know how to address what is just not true, other than to tell you that it's just not true.
You can tell me that when he visited with his mother, can you give me the dates, places, times?
So my client's son has tried to reconnect with his mother. He's currently in counseling, and he's, working to get to a place where he can really reestablish the relationship that he wants to have with his mom. However, unfortunately, when he or his father try to talk to Miss Eldridge, it inevitably leads to a very volatile situation. And so, it's not that Mr. Barnes is keeping his son from Miss Eldridge. The child is making a choice to not have face-to-face contact because the situation, even over the phone, becomes volatile. So he is actively saying that he is not ready to do that. They are definitely reestablishing a relationship with the grandparents, Miss Eldridge's parents. That is definitely a very positive step, and they are having very productive conversations and interactions with the grandparents, which has not always been the case, but even Mr. Barnes is having positive interactions with them. But the child is actually still having very volatile interactions with his mother, but she does have a way to get in touch with him, and they do have a way to communicate.
What was the volatile response, and when was that?
Yeah. Yes.
I'll let my client address that.
Yeah, so I think right before.
I'm sorry, I
Yeah,
didn't know the man if he's gonna address something.
Yeah. Can you raise your hand?
Do you solemnly swear or affirm that the testimony about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely, I do.
Tell me start with the date.
I think 2 months before the filing, Miss Eldridge that she had seen Cameron And again, he can kind of specify a lot of this as well, more so. And I think we had constant communication with the grandparents because that was the positive. He would spend more time. I didn't know this until he got with.
No. I like to stay focused. You said that she had a volatile situation. What
Right,
was it,
right.
and when was it?
So the volatile situation, and the most recent one I can remember, I was at a.
No, I don't want about the recent one. I want the one that started your position or your son's position, that they had a first exchange and it was volatile. When was that first exchange and how was it volatile?
And are we speaking in terms of visitation, Your Honor? Is what we're.
What else were you considering?
So what prompted this again was
No, the question was, you asked me, was we consider a visitation? And I said, yes. Is there something else? What's the answer to that question?
Well, the reason why, because it's a lot of different moments where, again, he'll be on the phone. And again, this has happened numerous times. I would just have to go in my call log and look in when he was speaking to her. Because he has my
So you're talking about a phone call versus an actual personal interaction.
Right, those personal interactions he's had recent ones and ones prior.
Not recent ones. I want to focus on point one, okay? Point one was what happened volatile. Was that an in-person volatile situation or by phone volatile situation? That the first thing that you said, the first time they had an interaction, you said it was volatile. What was it?
Chili's, we were at Chili's.
You met her at Chili's.
Right, we met at Chili's.
When was that?
Like I would say April of last year.
Okay, April of 2023. That was after the order or before the order?
I think after the order.
After the order, you all met at Chili's.
Right.
All right, tell me what happened.
So we got there. I obviously was there because I was kind of uncomfortable with what happened to him. So obviously I wanted to be there to make sure it went well for him. And I did want to have a conversation with her at the time too, to kind of find out what really happened. We got into Chili's. I was sitting there waiting with my son. I get there, she comes in. She's like, well, you're not supposed to be here. This is our time. And then she commences to pretty much in the doorway of that, she starts cussing and fussing in front of him at me for being there and being present. And because I wouldn't leave him by himself after what I found out what happened. So I said, okay, well, for his sake, I got to be there in my mind, just being present to make sure nothing said that's out of order, that they can have a common conversation, but it just wasn't going to happen because she got irate. So then I went to my truck after it kind of calmed down, and I agreed to say, okay, I'm not gonna leave, but I'm gonna let you guys speak. So they spoke on the bench because we didn't have a lot of time to speak and to stay, but I wanted to make sure she had time with him, right? So that was
a lot of time to stay.
No, we did not. I can't remember what it was at the time, and I'm sure my son could probably explain a little bit better than I can on this. But again, when we were there, that was the first volatile, cussing, fussing, mad. It's the typical type interaction I get, whether it's on the phone or doesn't matter. That's what I get every time. We had to have a conversation and I'm present.
Okay, so you went to Chili's for not really for lunch or dinner. You actually just intended to meet there since you didn't have time.
Just for them to meet, yes, to see each other after the incident, right? After I found out all those things and we had the court issued stuff, then I said, okay, well, let's try to start building some type of, relationship. And I don't want her to not see him, right, in whatever fashion it may be. But if he wasn't ready, because I kept asking, are you ready? He's like, no, he didn't want to. So the issue is that it's being presented like I'm withholding him, but I'm not. It's just he's pushing back on me. If I'm talking to him, hey, you want to see? He's like, no, I'm not ready. I don't want to have a conversation. If I got for calls during the week, he doesn't want to make these calls because he's still affected by what happened. And I still don't even know the full story.
Okay, so that was the first volatile and that was in person. Was there a second one in person?
Definitely Mother's Day. That one was over the phone. I know it was something.
My question though, in person.
It was in person for that was via phone, I would say. And it was more in person with the grandparents per se, because it kind of all meshed into one. We were trying to drop off her a Mother's Day gift because I'm like, son, it's still your mom. Let's try to get her something nice, right? Long story short, it was short notice, like, hey, can we come drop it by? I don't think she was at the house at the time. So we just left it because it was kind of like arguing on the phone again. And so he felt like, he was like, well, why are we even doing this, Dad? Why are we even pushing this envelope? Why am I going over here when she's angry and this, that, and the third? And I said, well, we still have to do this. So all we did was just leave it out on the driveway and we drove. And I talked to the grandparents saying, hey, can we at least bring it to you? When we were trying to get through the gate, she was present at the gate, right? And then, but we were hearing cussing and fussing through the phone, and we just decided, nope, I'm not gonna put him nor myself in that space again. Then with more cussing and fussing, I said, let me pull back, and we just dropped, again, we had dropped that gift off. That was the reason why we dropped it off, because we couldn't bring it for her without the cussing and fussing and fighting between her mom and dad, and vice versa, for me even being present, having him there to drop the gift off. Like, it's a Mother's Day. It should have been simple. Hey.
Oh, okay, I'm confused. You saying you're fighting with her mother?
No, she was over the phone. Like, we were hearing it in the background when we were coming through the gate of the neighborhood. So we were hearing them arguing over the phone. Her mom was screaming over the phone, arguing. It was just a lot of drama in the back.
Arguing about what?
About, I guess me coming there to drop a gift off for her, from him. So we just ended up having, they were like, no, don't, the dad was like, don't even show up. We got too much going on here. So we had turned around and we dropped that gift off at her home. So that's what happened that day. It was just a lot of chaos. And we had to wait
Why were you trying to drop the gift off at her mother's home in the first place?
Because we had been he had been seeing them little by little, one, because she was going like through cancer treatment. So she was like, hey, can I see him? So when I had jobs out in that area and stuff like that, I would let him drop in for 10 minutes, 15 minutes. And I would sit there, let them talk, let them have interactions. That way they would at least have some type of relationship. So you can kind of talk it through. Hey, this is what happened, grandma, blah, 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 blah. I don't know what they talked about, but I just wanted to make sure that interaction was happening to where he didn't lose. I didn't want to feel like he lost everything, is my main thing. I didn't want to feel like he lost his world, because that's what he felt like. And it was rough to see that he didn't have that interaction with anybody in the family. So I would still keep up with the father, with her.
Why were you on the phone with her if your intent was to silently drop off the gift?
Say that again, Your Honor.
Why were you on the phone with her if your intent was to silently drop off the gift?
So we were on the phone with her, Your Honor. I think I got it just to be sure. I was hearing them in the background. Right. And then when I did call her, it was arguing. Like,
I don't know how you can hear somebody in the background if you're not on the phone with them.
We're in two different places. When I was at the edible arrangements, we called her. That was the cussing and fussing in from her specifically. But when we got trying to get to the gate to drop the gift off first, after the edible arrangements, right? That's where we kept hearing the arguing in the background with her and her parents, when, via whatever.
Okay, let me just back up. You call her at edible arrangements because you wanted what?
Letting her know that, hey, can we bring a gift by, whatever. She's like, I'm not home. And she got irate then.
Okay.
Right.
I'm not home. I thought your intent was to always drop it off at the grandparents' house so that you wouldn't have interaction with her.
Right. But I felt it also, because this is a torn moment right here where I wanted to make sure that he could have some type of interaction with his mom. But if we couldn't, I knew the grandparents was the next best thing, because that's who I have the positive interaction with. Right. So if I can't bring it to mom, then we can at least drop it off, son, because I was picking up more than one gift. So I wanted to.
So why would she be at her mom's house if you told her the gift was coming to her house?
We didn't know she was going to be there. We had no clue, because we were coming through the gate to drop the gift off.
Okay.
So her truck was there.
Okay.
We were right behind her. Couldn't have made it up. It was right, boom. She's right there coming through the gate. But over the phone, because we were on the phone.
So you never did drop the gift off?
We ended up we couldn't get to the grandparents to drop the gift off to them. So we ended up circling back.
So she's cussing at what?
Say that again?
What is she cussing about?
She was cussing about the fact that, if I'm not mistaken, let me let my son kind of clarify.
No,
I can't remember everything.
What was she fussing about?
She was just fussing about us trying to get to her and the last minute, not really being able to see him. If my recollection. So that's what I do. I remember.
So she's fussing about it being last minute and her not being
Right.
able to see him.
Right.
Okay. And at the time, your intent was for her to see him.
At least have some, to drop the gift off and just be kind to his mom, to try to break the ice.
So what was she, why was she angry if you were letting her see it? Do you know?
Just short term, that's her to specify.
Okay.
I honestly
All
don't.
right. Okay, so that was the second time.
Third interaction.
Physical, in person.
Physical in person, I think, I'm thinking, yes, he came home and told me after he was with his grandparents, where they went to like a restaurant, I think, where I didn't know the mom was gonna be there in the first place, but okay, fine, whatever, right? They went out to eat. And then he came back and told me, yeah, Dad, it was good, but I could feel the tension. And then I think it was talks about like the court case he was telling me about. Like he kept being talks about the court cases and things like that about what's going on. And he felt uncomfortable. Then he was put in a position to be around the stepfather, which he was uncomfortable with, who participated in the alleged abuse, I would say, right? Because all I know is my son knows that. He knows what happened. So that's why we're here in the first place. So he was uncomfortable trying to speak with them. He knew it didn't feel right. He's like, Dad, something's wrong. It just kept being talks. And then the grandparents again were participating in these negative talks every every car ride. And this has been happening. Those type of interactions have been happening ever since. And I kept thinking in my head it would stop, but even to the most recent stuff, it kept happening. They
Okay.
continue
So
to want to talk.
when was the eating situation?
I think it was July, something like that.
Okay. Now, was there any other physical interactions?
Not that I can remember myself. It's just like I said, it's been a lot.
And the phone call interactions, tell me about those.
Usually the phone calls are she usually does like a check-in with him, and then what he tells me is in about 10 minutes, it usually kind of goes off the deep end. After about 5 to 10 minutes, is what he specifies to me.
And deep in how?
More talking about, well, your dad doing this, your dad not letting me talk to you, your dad's not this, and that's the kind of stuff that he come back and tell me. And I'm like, son, just try to eliminate that. Just worry about, and if it starts to happen, tell her you got to go, because I don't want to keep having to hear about how bad his dad is every 5 seconds, or a lie about how I'm not letting him see her and all these type of things. So he really tries to have the information, but again, it just boils down to the hatred toward me. Is what usually happens on that phone, whether it's him talking to the grandparents or vice versa with her. So it's just a constant barrage of the anger toward me that he has to keep receiving. And when they try to talk about just themselves and their relationship, what he comes back and tells me is that, hey, Dad, it's just she's not listening. She's not listening to what I want her to hear from me, right? Then that's one of the biggest things. And then it's because it's so angry. Well, you're not a man. You don't talk to me this way. X, Y, and Z. And if he's disrespectful to her, I think he only did that one time we were at the park. And I said, you can't talk to your mom crazy, son. Just because you're angry with her. I said, you can't be, it's just constant toxicity, just head bumping over and over again. And I'm like, I just want the peace, because I'm not even in it now. And it's still crazy.
Okay. All right, thank you so much. Let me swear Ms. Eldridge in. Raise your right hand. Do you solemnly swear or affirm the testimony about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, can you recount to me your situation, the situation on April at Chili's?
Sure. So Chris had texted me and told me that Cameron had a little bit of time and wanted to see me, and that we could spend some time together at Chili's. I get to Chili's. I was under the impression that it was going to be Cameron and I having dinner together, or early dinner together. Cameron had a menu sitting right there in front of him. And so if Cameron is sitting in a booth, basically like if you and I are looking at each other, he's sitting where you are, I'm sitting where I am, Chris is sitting in a booth, or the defendant is sitting in a booth, 2 booths behind, staring at Cameron. So I'm like, I'm not understanding like why you're even here. Like, this is the very first time that I'm able to see Cam. Like, it needs to be about he and I. And it just felt very intimidating. So I told Cameron, I said, well, why don't we just step outside and you and I can sit on a bench and just kind of have our own time to talk since you don't really have that much time. He is correct. When he approached me in the corridor of the restaurant and was like, well, I'm just trying to talk to you. Now, Judge Barry, this is the first time that I've spoken to Chris since he took Cameron out of the household in October 2022 and told me that I would not see Cameron again until we were in front of a judge. And they have all of these text messages to show that. So this is my very first time. I had no clue about court. I don't know if this was prior court to court or after court, but that was the only physical interaction that I was given time to spend with Cameron. But he is right. I told him, I was like, this isn't even about you. This is my time with Cameron. You shouldn't even be here. Like, why can't you just allow us to have time to spend with each other and then not make it about you? That was that situation. We sat outside for probably about 30, 35, 40 minutes. And then Chris is texting me, telling me, you got 5 minutes left. Okay, your time is up. Cameron needs to come to the car. And Cameron leaves. There was no negative interaction between Cameron and I. It was the only brief disagreement between his father and I, just because you're literally sitting here a booth away, staring at the back of my head and looking at Cameron. Of course, that's going to seem intimidating. That I don't know if you're telling him what to say or if you're reading his mouth the entire time. It was just an uncomfortable situation for everybody, and he shouldn't have been a part of it.
Okay, and what about the Mother's Day incident?
So Mother's Day, I had been asking to see Cameron for Mother's Day, no response. And then they called me at about 2 something, and I had just got done having brunch with my husband. He took me out for Mother's Day, and we were on our way to go and pick up the kids from my parents' house. Chris calls me, and he's like, hey, are you going to be home in, I need you to be home in 10 minutes so that I can drop this gift off to you from Cameron. I said, well, is Cameron in the car? I'm not going to tell you that. I said, it's Mother's Day, Chris. Like, I'm trying to see Cameron. I don't want you. I'm not trying to see you. And he basically hangs up the phone after that situation. He wouldn't tell me if Cam was in the car. And he said, well, fine, we're just going to drop it off at your house. So I happened to be pulling up to my parents' house, going inside to pick up my other 2 children. And I guess he's behind me. I don't know. I actually didn't even pay attention. I didn't know that they were behind me. There was no arguing between me or my parents. I'm not sure where any of that came up. But by the time I got home, there was already a gift sitting outside on the driveway. So I don't, it was my understanding that they dropped the gift off to me at my house first, and then they were going to my parents' house to drop their gift off to them. I don't know the order of things, but when I got home after I picked my other 2 children up from my parents' house, there was a gift in the driveway.
Okay, and the July dinner.
So to preface that, there has not been any, again, that Mother's Day incident was over the phone. That wasn't physical. I never saw Cameron. And again, it's Mother's Day. You would have thought that he would have made an attempt to allow me to actually spend time with Cameron on Mother's Day. And that never happened. They called me last minute saying, you need to be home in 10 minutes. We're about to go drop a gift off. When it came to July, there was no visitation extended to me. That was extended to my parents. It just so happened, and like he said, that I didn't even know that she was going to be there at brunch because there was no visitation for me. Of course, when my parents had him, they're like, Jasmine, let's go out to eat, bring the kids. That was Cameron's first time meeting his little sister. He had not met his sibling before. So it was a positive experience. I have tons of pictures. We had a great time. There was no negativity. He hugged me. He hugged all of our family members. I have pictures of him standing right next to my husband with his arm wrapped around him. And we're just one, at the time, happy family. And so we saw Cameron, and that was it. That was the last official time that I saw Cameron, but that was through him granting visitation to my parents, not to me. And since then, in July, literally the weekend after Cameron visited, Chris reached out to me and asked if I wanted to spend time with Cameron for his 15th birthday. He said he's only available from 9 to 12, and he was going to go get his driver's permit. I said, sure, if 9 to 12 is all we're going to get for Cameron's birthday, I'll take it. Chris ends up getting served 2 days prior to Cameron's birthday. And then he sends me a text message, which the opposing counsel has, stating that you're a threat to Cameron, and for his safety, you won't have any contact with him until we go back to court. And from then on out, Judge Barry, I have been blocked. The attorneys had an understanding in, I believe, August or September, that we would establish phone call visitations with Cameron every Tuesday and Thursday at 8 p.m. Not one telephone conversation to date has been completed. With the opposing counsel, I have sent text messages every single Tuesday, every single Thursday at 8:00 p.m. telling him that I just called Cameron, no one answered, and it became very obvious that I was blocked. By December of last year, prior to me having my daughter, I realized that the telephone was completely disconnected.
When was Cameron's birthday?
Cameron's birthday was August 2nd. Chris was served July, I want to say 29th, if I'm not mistaken. And then he took away that visitation and said that I was a threat to Cameron, and for his safety, he was no longer going to allow Cameron to see us for his 15th birthday. I continued to call that day, send text messages that day. We were blocked, and we've been blocked ever since, Your Honor. So then in December, I realized that the telephone line disconnected completely. I reached back out to my attorney, to let her know, hey, I have no way of getting in touch with Cameron. The phone has been disconnected completely, and Cameron doesn't have his own cell phone. Then in in March, my attorney reaches back out to the opposing counsel's attorney and says, this is a clear-cut case of alienation. You have to provide my client with some type of feasible contact information for the minor child. This is inappropriate. I never received anything. And then my last thing, and I promise I'm wrapping it up, is when I finally did speak to Cameron. He happens to call me. First, Chris calls me from his new cell phone.
What date?
On April 1st of this year, so less than a month ago. We're almost a month out. Chris calls me from his new telephone number, and I hear birds chirping in the background, and he says, hey, this is my new cell phone number. I'm going to give Cameron your number, but you all have a lot of things that you all have to work out and discuss. Cameron is, not very happy, but, it is what it is. And I said, well, I wonder why, Chris. And he's like, I'm not going to argue with you, and hangs up in my face. 45 seconds later, I get another telephone call from a different number, and this is Cameron now calling me. Same birds chirping in the background, which I'm assuming this is the park situation that he was referring to. I don't know. Birds chirping in the background, and Cameron is calling me. Cameron is pumped up. He is disrespecting. He is being very rude. He says, the first thing that comes out of his mouth is, this whole situation is quite honestly just foolish. I don't even know why you're even bothering to reach out and call. Like, this is all just dumb. And I said, what are you talking about? He was like, you're taking my dad to court. I don't understand. I chose the parent that I wanted to live with, and you just need to accept that. And if I don't have to have a relationship with you. And I said, Cameron, I've tried to reach out to you for months now, every Tuesday and Thursday, to have a telephone conversation with you, and I have been denied. I've been blocked the entire time. Throughout that conversation, Cameron is very angry. He's very irate. He's just an unrecognizable child, Father God. It just feels like he's been manipulated and manipulative. I kind of continue to lead with love in that conversation, letting Cameron know that, hey, you are so missed. We love you. We haven't seen you. You haven't asked about your brothers and sisters. When am I going to be able to see you? Well, I don't know. It's up to my dad. I would have to talk to him. And I said, okay, well, I would love for this to be a good starting point for us to try to rebuild a relationship and talk on a routine basis now that you have a telephone. He said, well, that's fine. And I told him, I said, Cameron, but why are you so angry? You haven't seen me in a year and a half. I'm sorry, you haven't been back to this house in a year and a half. You haven't spoken to me in 7 months. This is the first time I'm hearing from you in 6 months. And why are you so upset with me? Like, there's nothing that I have done. In this conversation, Cameron has called me manipulative.
Ms. Eldridge,
a liar.
so
Yes,
some of the concerns that your son mentioned to the court, when the court made this order, you're saying no one's ever indicated to you, Cameron has never said to you, Mr. Barnes has never indicated to you what son's name's Cameron, right?
Cameron, you're correct.
Yeah. What Cameron is angry about or what he's concerned. So you have no clue what his allegations against you and your husband are?
Yeah, no, now I do, yes. But again, Your Honor, when all you're talking about with the
How
child,
did you find out?
the way that I found out that, well, the way that I found out that Cameron was angry was again in October, on my 1-year wedding anniversary, October 2022. Cameron was there with his dad for a regular routine visitation. And the day that Chris was supposed to return Cameron, he texts me and says that he's not bringing Cameron back because I'm physically and mentally abusive to Cameron. And he that he already had everything in line with an attorney or a judge that he did not legally have to bring him back. And so he did not bring him back. During that time, I had a high risk pregnancy.
Specifics other than mental and physical abuse. Has anyone said, this is a particular incident where he said you touched him or said something abusive towards or against him? Has anyone said to you what those allegations are?
No. Oh, yes. Okay. So I understand what you're saying. The first time that I heard anything about the allegations as far as me being abusive was in a week after he did not bring him back. DFACS called me and said that the reason why they weren't bringing him back was because I was physically abusive to Cameron, that I punched him in his face and nose 12 times. Now, ironically, Judge, I have pictures of that weekend that they're referring to. Cameron is in the swimming pool. Cameron went to a Braves game with us. We were sitting there and like one happy family. So these were all, I hate to say it this way, but these are lies and fabrications. I've never abused my child. In 14 years, I have never abused that child. I don't spank him or anything. The incident that took place was in his 8th grade graduation in May of 2022. Cameron stole money out of the house, and he took a gaming laptop that we purchased for him out of the house, as well as some clothes, and he was going to sell them at school in exchange for a BB gun. Cameron did get the BB gun from the other child, and he took his book bag to my parents' house. The BB gun falls out of the book bag, and my mother happens to see it. She goes in all-out panic. She calls me and lets me know, and Cameron is like, I gotta call my dad. I gotta call my dad. I told Chris ends up calling me saying, hey, I understand that there's a BB gun. I'm just going to come pick it up. It's no big deal. It's okay. I said, no, don't worry about it. I'll handle it with Cameron. And I'm also going to figure out where he got it from and get in touch with the other parent. So during that time, Your Honor, he was disciplined. He was disciplined. And he was put on punishment because we had a conversation about guns, about young Black boys with guns, about that you aren't allowed to have one.
During that incident?
No, ma'am. My husband has never put his hands on Cameron ever. Ever. And I would like to just add some background to that if I could.
No, not right now. Okay.
Okay.
So, all right then. Thank you.
Sure.
One more thing. Let me go back to Mr. Barnes. Mr. Barnes, you said that he was in counseling. What's the counseling schedule and how long has he been in it?
We actually couldn't get in there early enough, but we just he had his first meeting yesterday.
He just had counseling.
Right, with a pastor. So when he's been with me, he had been baptized. I had been counseling him biblically. So he's been kind of turning over a new leaf at the school that he's currently at. So he's been talking to teachers, but the personal counseling session has happened yesterday. It was the first one that we've had, which helped him get to this point where
why did you wait? Why, if you see your son is angry, not visiting a mother, have brothers and sisters he's not interacting with, why would you?
Well, this is the biggest thing, Your Honor. Every time I tried to push it, he fought back against it.
Well, he's 14.
And he didn't, and every time he's like, I'm just gonna run away, Dad. I'm gonna run away. I don't want to see them. But they're thinking it's me telling him, hey, don't go see her. No, it's not.
I don't know if they're necessarily thinking it's you, but you're the adult, you're the parent. And when you see your children going through mental health crisis where they are rejecting people including people who are innocent, like their brothers and sisters, there's an issue. And you
I
have.
think the issue is that he keeps feeling like his
Yeah.
mom is continually lying to him. And in some of these
Yeah.
stories,
Well,
you know,
here's the
that's
thing, Mr. Barnes, since you're not at the table when they're seated and you're not in the home when they're having those issues, since you're not there, the only thing that comes up is what he's seeing. What if what he's seeing is skewed by the fact that he's 14?
Mhm.
Or what if what he's skewed is by a fact that he's depressed or some other situations?
I think it is that, Your Honor. I think
He's still a kid. And so what I'm asking you to do is that when you have a situation wherein there's a complete alienation of a parent, that should alarm you. Now, there might be reasons for it, obviously, and I can't remember specifically what he said to me. And I was trying to look for my notes or recording so I can remember. But I kind of get the feeling that what he said to me was that it was mostly mental, like the things that they were saying to him. I didn't get the feeling it was a lot of physical stuff. There might have been one incident where he recalled something physical to me. But I think by and large, because if it was a lot of physical, I probably would have put in here like some type of supervision or something like that. So I think it was mostly mental, kind of growing up in that situation. And so I'm not necessarily saying that's good. I don't know either. But I do know that when you have a situation wherein you have a kid who's completely refusing to be around a whole group of people, grandparents and siblings, that and that's alarming. You should be worried about that. That means something is going on that you can't get through to him. And then if the first thing you're doing is you're going to a pastor who may or may not have the ability to address his concerns, I don't like it. I don't like it at all. Give me one quick second. I apologize. Let me allow any proffering that the attorneys wish to make regarding the motion. So I'll start with you, Ms. Verheen, if there's any additional proffer you want to make to the court.
Yeah, Your Honor, I would just say again that I do not think that according to the order that you entered in April of 2023, I believe it was. I think I have my date right.
Yeah, you got it.
I do not think that the plaintiff has met the burden of showing that there's been any material change in condition or circumstances that would warrant modification of your order from that date. So I do believe that her motion to modify custody should be dismissed along with the other petitions to modify child support and for contempt. Based upon the testimony that you've heard today, my client has shown that Cameron is not in any shape or form, willing to or wanting to have, a lot of contact with his mother. And by the court's own order, you found that there was mental abuse present and had previously ordered that visitation should be at the discretion of the father. And I believe that that was mostly based upon what you heard from Cameron at that hearing. The mother was not present at that hearing for whatever reason she wants to claim that was. We tried to give her notice both by a private process server and publication, but she did not appear, and she had her chance to appear at that hearing and have her say. So I feel like the court had enough evidence at that hearing from Cameron to make the order that it made, and that order should stay in place.
All right, thank you, Ms. Banksworth.
Your Honor, I would proffer to the court that the party's testimony alone is sufficient for the court to make a determination that there has been a material change in circumstance, namely that Mr. Barnes has utilize this order as a weapon in a way to preclude my client from ever having any relationship with this child. Why do I say that? By his own testimony, he admitted that even when he reached out to mom, because the child indicated he wanted to see mom, he put her on a time clock. Her testimony was that he gave me 30 minutes.
I'm
He
sorry,
said-
Your Honor. Please forgive me, but we lost Miss Eldridge.
Oh, you're right. We did. Let me text her.
Okay, how long has she been gone, Miss Marsha? Have you noticed?
Maybe about 2 minutes. I was just trying to catch Miss Banks' Ware on a quick breath.
Paying attention, okay.
Okay,
Maybe about 2 minutes, Your Honor. I was trying to catch Miss Banks' Ware on a short breath.
okay, let's just pause real quick. On the Ekman case, it'll clearly be after lunch. I'm just gonna ask you guys just to return at 1:30. So on the Ekman case,
Understood.
gonna ask you guys to return at 1:30.
Okay, Your Honor.
Ms. Kissé? Okay, great, thank you. Make sure you let your clients know. I'll see you back here at 1:30.
Thank you, Judge.
Okay,
And she said she's logging back in now.
okay,
I'm not sure how much she missed, but what I was trying to say, Your Honor, is that by the party's own testimony, because it sounds like Ms. Verheyen and I heard two different things. What I heard from Mr. Barnes is that he reached out to my client in April. He did tell her that her own testimony, I'm giving you 30 minutes. He sat so that he could, as she said, she felt like it was intimidating to the child because he was looking right at the child while she was trying to have a conversation. She moved them to the bench so that they can talk. And even then, even when he said, I left them alone, he's out in his truck or wherever he's at, and he's texting her saying, you got 5 minutes. So she didn't have time to even have a real conversation with her son. The other times, because you specifically asked him, when did she have face-to-face interaction with this child where she could visit with him? And I think it was one time other than accidentally seeing him in July, which he allowed the grandparents to have visitation. And he mentioned the grandparents over and over, even though they're not parties. He mentioned the grandparents to say, well, I think it should have a relationship with somebody on her side. So he's decided that it should be her parents and not the mother of this child. He's the one that's facilitating visitation between the grandparents and their son. They're not parties. They don't have any custodial rights. But because he has authority under this order to do as it appears to be as he sees fit, then the only access he's allowed to this child is through my client's parents. When she indicated that she reached out to him on Mother's Day and he took the time to go buy something for Mother's Day, her testimony is she even asked, well, is Cameron with you? You don't need to know. It's Mother's Day. Why would she not want to see her child? Because dad has all the power and he's using it in such a negative way, such that my client, if it continues, will not have any relationship with this child whatsoever, because dad has deemed that it's not fit for her to have access to this child. And even if Cameron decided, okay, well, I'm feeling a little uneasy, the answer is not keep him away from mom. The answer is to let them work through whatever the issues are. And that hasn't occurred. That has been suggested, though. Real therapy, reunification therapy, that has been suggested. And the response to that suggestion is, we're moving to dismiss. We don't think you have a case. We don't think you should have filed. That's been the response. The response is, we don't care about your relationship with this child because this child says he don't want to have a relationship. And that's okay with dad, apparently, because he's fighting this tooth and nail for my client to have no access to this child. And as the court said, that should be alarming to dad, but apparently it's not, because we're here today arguing a motion to dismiss as opposed to trying to figure out a way to reunite these two parties. She's going to always be his mother. That's never going to change. But he's 15 now, and as he gets older, if he's allowed to not have any access with his mom, she may not be able to repair it once he turns 18. She feels like he should be able to interact with her, his brothers and sisters that he's got from her other relationship with her husband. She's expecting now, have another baby on the way. She wants him to be a part of the family, as he was since the original order. Mom had primary custody of this child from October 2010 until dad decided in October of 2022 that this child couldn't go back to visit. She had primary custody. And at no point in time did she ever try to alienate this child from dad. And as soon as dad gets custody, what does he decide to do? To alienate this child from mom, who's been his primary custodian most of his life. And that should not be okay. So we're asking the court to deny this motion to dismiss. My client provided evidence in court in November to show that she was actually terminated from her position. The statute clearly says when someone has involuntary loss of income, once the petition is filed, the court is to try to have a hearing as soon as possible. But not only that, any amount of money that's attributable that's to determine the support that's been lost, there should actually be no child support from that date forward. There is an arrears that's out there now because the motion to modify the child support, but based on her not having a job, has not been heard. They're moving to dismiss that. Counsel is saying, well, you know, I don't have any evidence she's not working again. But we showed you evidence that she was unemployed. She can't show you, other than her saying, I'm not working, that she is not working. She can tell you what she's tried to do to find work, but she would testify today that since she's found out she was pregnant, she has a high-risk pregnancy and she's been on bed rest. So she hadn't been able to go out and get a job. But so the petition to modify the child support needs to be heard. And not only that, Mr. Barnes is coming to this court asking for relief when he knows he's in contempt for the 2020 order. I can tell you that he owes the $3,800 and let me get the exact amount for my attorney's fees that he has not paid. Like he has not paid it to me. He has not paid it to my client. I think I listed it out in my order. $3,812. That was ordered. He was supposed to pay it over time. Not one dime. He didn't pay my legal fees. He was supposed to pay past due child support to my client, $1,485.55. Not one dime. He hasn't paid it. Even when I responded to her motion to dismiss, I even pointed out to the court, it would be one thing to ask to dismiss if he had evidence that he had paid and we were just being frivolous and filing and knowing that there was evidence of him paying. That wasn't their position. Their position was, we don't quite know exactly what he owes, so then we're going to dismiss your contempt. By the way, there is a contempt that they filed too, because there was an order that was put in place. So when they filed an answer to the modification that we filed, they did a counterclaim for contempt against my client, saying that she was in arrears for not paying child support, which she was. That's not in dispute, because he owed her so much money that he didn't pay from the 2020 order. It didn't make sense for her to start giving him $519 a month when he owed her almost $12,000. But I got the specific amounts in my motion. So I say that to say, and I know the court is not hearing all this today.
Right.
Everything needs to be heard. If he's got proof that he paid my attorney's fees, show it to me. I dismiss it. He can't do it because he never paid them. If he's got proof that he paid her the $1,465 for the past due child support, show it to us. We'll dismiss it. If he's got proof that he paid for the past due medical premiums, show it to us and we'll dismiss it. We haven't dismissed it because he's provided no proof that he ever paid. So he does have some nerve coming to this court, asking for any relief when he comes to the court with unclean hands. So we're asking the court to dismiss their motion or deny their motion to dismiss this case. And I put this down for a hearing so we can have all these issues heard. But specifically, my client wants contact with her son. That's what's most important to her. She wants a relationship with Cameron. Whatever we need to do to get that facilitated, she wants that to be done. What we do know from this past history is that if the order stays the way it is, she will not have any contact with this child because the efforts that she's made have not been successful. Whether it's trying to reach, she said, she testified herself, I try every Tuesday and Thursday because I had a conversation with counsel at the very beginning of the case. Like, let's try to set up something so she can at least have phone contact. Hadn't happened. No phone contact, no visitation, other than, like she said, she bumped into her parents with the child in July. But there's been no regular visitation. No every other weekend, not even one time every other week. There's been none of that because of the way this order has been utilized by Mr. Barnes. And we do not believe that that's in this child's best interest.
All right. So the child initially presented to Mr. Barnes that there was either some physical, but certainly mental concerns that he had living with his mom. I think in his affidavit, or I don't know if it was verified or not, but he put some things down there. And I think initially he was saying he may have said something about threats. Let me see exactly what he said. I think he said threats. So I think he indicated that there were threats that he was concerned about. He said he had a lot of mental stress on him. I do remember him talking heavily about just a lot of mental stress on him when he's dealing with his mother and her husband. So he was under an extreme amount of stress. Are the other children that you have, Miss Eldridge, are they all from the husband that you are currently with now? You're on mute.
Yes, Your Honor. My other two children and the expecting child is with my husband.
Yeah.
And I helped raise Cameron for 8 years prior to this situation. He's not new.
Okay. Yeah, I don't think he's necessarily new, but I don't know. I just remember it could have been something dealing with the dynamics of how those children are handled. I don't know. I can't recall directly. I do have some flashes of that conversation, and I don't have a recording of it that I can.
Well, they're toddlers, so they are handled differently than
Right,
14.
but a 12-year-old won't know that, though. Sometimes children
Never.
don't. Sometimes children don't get that, and so they feel it's a difference. You just have those dynamics.
Yeah.
You have children, so I can't remember exactly what it was, but those are some of the dynamics that I kind of tangentially remember being brought up. But what I'm trying to say is that he then went to his father's house, and his father provided him some mental relief. I remember him talking about that, and that was really important, that his father provided him some mental relief. So I think Mr. Barnes is protecting his son. He believes that what he's doing is giving his son what he wants, and that is protecting his son. I don't believe necessarily that Ms. Barnes is doing things just to be a hell raiser, or just to make things go awry. I think Mr. Barnes is doing what he thinks helps his son. The problem that the court has is that, and this happens plenty of times, is that parents will believe that they're helping their child by giving them what they want. And that is not always the proper way of handling your circumstances when you have kids who are alienating a parent. And you think, Mr. Barnes might be thinking, and I'm not a psychiatrist, so some of this might be completely wrong, but that's just the problem. The problem is neither of us are. And there is a place where this child needs to be, and it is not in counseling, because it's clear he needs some counseling. And so I think your position was, and the court's position was, giving you control, was that so that you could protect your child. But I don't think that necessarily means the protection is giving the child what he wants. Okay, that's not the protection that you should have to be focused on. You should be focused on making sure that the child is mentally healthy. It doesn't necessarily mean giving him what he wants, which is, okay, I just won't deal with mama because that's just simply easier for me. It could be simply easier for him, but that doesn't mean that in the long run it's going to be better for him. And so that is the concern that I have. So I'm not trying to throw you under the bus, but I do want you to recognize that just because your son says, I don't want to see mom, then you go, oh, well, he doesn't want to see mom. I did my part. I asked, because if that were the case, then we would have plenty of alienated kids, because they're 12 and they're 11 and they're 13 and they're acting like children. But you are an adult, and you got to understand the importance of having relationship with both parents. And I don't think having one situation where you meet with mom in April is sufficient. It's not. And the reason why it's been so long is because the child hasn't had any type of counseling or therapy to have some type of reunification. or some type of situation where you as a father can then continue to have mom and child have relationships. They can't have a relationship if your first thought is, I'm going to give the kid what he wants. Because if that's your first thought, then counseling would not be important. But you, as the custodial parent, you got to make sure your child is mentally healthy, and having a relationship with his mother is important, you know, to the extent that can be had. Now, I understand there's some situations where that just can't be. But I don't think, from what I remember hearing from this child, that's where we are, because there are certain things that I know that I would have done as a judge that would be different from what's in this order, because I know how I handle things. So I don't have any actual recall, but I know whatever it was, it wouldn't have put me in a situation where I would just say, oh, let dad decide. But I want that to be very clear, because both of you have good points with regard to what's happening with your child. You're just on different pages. Like, for example, on the Chili's, it's a good thing that you wanted mom to have a moment with her son, but it's a bad thing to encroach, because if you're sitting two seats away, that you have a 14-year-old, he can come back and tell you, if he felt uncomfortable. You don't need to literally be in the same atmosphere. You could be, like you said, in your truck waiting for them to come out. So those are just small things, right? And you're saying, well, I'm protecting my kids. Sure, that's exactly what you were doing. But you also have to balance that with regard to what messages you're also sending to the child, because now he thinks his mom is dangerous. So dangerous that you can't even watch that situation. They can't even be in the same room together without you present. So those are messages that you're sending, and they may be subliminal and you may not recognize them. But then after a while, you get what happened at the park, which is, I ain't got to talk to you. I don't have to do nothing you tell me to do. And you know how he knows that? Some message got sent. Okay. What happened in the park is a direct result of what's happening in April and Mother's Day and in July. There are messages and they are being sent. And you may not recognize it because you're doing what? Protecting your son. I'm gonna deny your motion to dismiss, because I do think there is material change of circumstances, not necessarily your behavior, because I think your behavior is exactly what I anticipated it to be, because that's exactly what you presented to the court initially. But his behavior is not. Okay, his behavior is to change, because his behavior is, I don't want to have anything to do with my mom to the extent that I feel free enough to tell her. And feel like he can be disrespectful. And even you recognize that and saw it. So, and I anticipated you to do what you were supposed to do, but I do not necessarily anticipate you to give in to what your son absolutely wanted and not give him the mental health that he needs. So in the interim, I'm going to rule that I'm going to deny your motion, and I'm also going to require you to have him placed in reunification therapy instanter. And then after that, we'll figure out what goes next, because at the time the court is giving you the ability to co-parent and make some good decisions. Let's see what you do. All right, so reunification therapy immediately. The phone calls will start. And additional visitation as you determine right now, until we have additional hearings, because I do need to speak with him again, because I just cannot recall what he said to me at this juncture. Okay, so I'm going to put hearing. We're going to have a status in 6 weeks and kind of see where we are. All right. Okay. All right, Ms. Banksworth, if you don't mind writing that up for the court.
I will, Your Honor.
All
Hi,
right.
Judge, can you tell her or explain when you want that, please?
Huh? One more time, Ms. Harris.
Can you explain when you want that order?
Oh, the time frame. Ms. Banksworth, when can you have that to the court?
Give you a deadline. I got you.
Huh?
I said, she said, give me a deadline. Okay.
Right. So she don't have to be, yeah, because I'll be bothering her like, when is that Barnes order in? And she'll be like, well, you didn't give them a deadline.
Well, I do have a trial starting on Wednesday in person. It's a 2-day trial. So if I could have at least until probably Friday, I could probably get it by Friday.
I'll have it on Friday.
Okay,
All right. Thank you. Y'all are free to leave.
thank you.
All right.